going to give the floor to Catrinel Brumar. Catrinel Brumar, she's the Romanian government agent for the European Court of Human Rights and also lecturer in international law and human rights at the University of Bucharest. Catrinel, please.
Good afternoon. I must begin with a confession. I don't know if Titu Maiorescu staff will be happy to have me. It was Nicolae Titulescu University, so I have the privilege of sharing this topic, the domestic application of the European Court of Human Rights case law by domestic courts with a former colleague of mine in some summer schools courses, Professor Guțan. I will try to offer a brief personal perspective of this direct application, and of course, I'm eager to hear Professor Guțan's presentation that will definitely complete my own perspective. As the current section of today's symposium is entitled The International Law in Domestic Law, my brief intervention will not concentrate as much on the European mechanism for the protection of human rights, that is the European Court of Human Rights, but rather on the manner in which domestic courts refer to its case law. Still, I could not begin without recalling the fact that the European system, created and developed based on the European Convention on Human Rights, is considered to be at present the most effective human rights regime in the world, largely due to its intricate character and to the position achieved by the European Court. The Court, which has final jurisdiction over disputes concerning the content of the Convention, over the interpretation and application of its substantive provisions by the contracting parties, and as a consequence, over their compliance with the Convention, exert over national legal systems an influence that is qualified as constitutional by some authors due to its position, as an institution competent to determine the law in an authoritative manner, and to its concept of precedent. However, the Convention is designed to be applied primarily at the domestic level, and the national judges are the first and the most important actors in supervising the respect by the state party in whose legal system they operate of the conventional standards. If the Court has final jurisdiction in terms of Article 32 of the Convention over all matters concerning the interpretation and application of the Convention, the domestic courts have the primary competence in interpreting and applying the conventional standards, and as the Court constantly recognized, because of their direct, continuous contact with the realities of the country, they are in a better position to evaluate if the rights and liberties set in the Convention have been observed. It follows that the national judge is the first called to verify the observance by the state of the substantive provisions of the Convention, and only afterwards the European Court, if an individual lodged an application, takes a view into the national legal order. In assessing the observance of the conventional provisions, the role of the national judge is, in my opinion, twofold. The first approach is a reactive one. Faced with the previous conclusion on a violation of one of the rights guaranteed by the Convention or its protocols, in a judgment issue against its state, the domestic courts target the domestic court targets the prevention of similar violations in the future. This happened in the Romanian judicial system, for example, after the Sabău and Pârcălap judgment was delivered, and the national courts began to restrict the application of ancillary penalties, such as the suspension of parental rights for the duration of one imprisonment, to cases where the offense for which an individual was convicted was related to questions of parental responsibility, or where allegation has been made concerning a lack of care or ill treatment of children. Still, these demarches, as Mr. Purgurides, former member of the PACE, put it, second best. The most important action a domestic court could have is a preventive one. The preventive demarche too, in my opinion, has two aspects. The first one, known to give full content to the principle of subsidiarity and to express the authoritative character of the European Court's case law, aims at giving due consideration to decisions and judgments delivered in cases contravene the guarantees of the right to freedom. The second aspect of the preventive demarche, although more difficult, is the one element that indicates the fundamental role played by the national judge in interpreting and applying the European Convention. That is, to refer to the general case law of the court in order to identify and develop the rules instituted by the Convention, thereby contributing to the observance by the state of its commitment. This implies that the principles flowing from the European Court's judgment be taken into account in deciding on an issue that was never before raised before the European Court, or that was never before raised in similar terms. This idea is founded, in my opinion, in the first article of the Convention, that not only requires contracting parties to secure to everyone within their jurisdiction the rights and freedoms contained in this instrument, but also, as it refers to the content of rights as defined in the Convention, that there be a common content all parties respect and protect. It is true that such an endeavor is not an easy task, especially when the European Court's philosophy and the national legal system do not coincide. I have here in mind the building by the European Court of a precedent-based case law, while some of the states have a Romano-Germanic system, and the adaptation process in those cases may be more long and more complex. The national judge will in the future take into account the court's jurisprudence in its own decision-making, and that goes beyond the incorporation of the Convention in domestic legal order. As the conventional provisions could not be interpreted in divorce from the case law, the European jurisprudence must serve not only as a guide, but as guidance to national courts. In my view, the recent Grand Chamber judgment of the court in the case Sindicatul Păstorul cel Bun against Romania shows, in essence, that such a preventive analysis from the domestic courts is favorably regarded and appreciated by the court. To accompany him or her in this path, the Romanian judge has, like other national judges, tools but also barriers. As tools are concerned, the supra-legislative force that the Constitution confers to the European Convention facilitates the judge's task and offers the possibility to set aside a domestic provision considered to contravene the conventional standards. As the debates of the first panel showed, in monist regimes, the domestication of international law is easier than in dualist ones. Still, even in the Romanian system, there are questions and challenges. As for the barriers, the preventive approach of the judge could not be complete in the absence of similar actions by the legislative and the executive branches. To take another example from the case law against Romania, the Pantac case, in order to give full effect to a European jurisprudence that had stated already in 1979 that a prosecutor is not a magistrate within the meaning of Article 5 of the Convention, a legislative intervention was necessary. Another barrier relates to the availability of the case law in other languages than the official ones. Extensive knowledge of the case law is not attainable on a large scale without its dissemination in the different official languages of the contracting parties. As a conclusion, I am confident, following the Romanian practice and the way the courts are dealing with the conventional issues, that even with the existing barriers, the national judge can and must assume its role as first guarantor of the primacy of the Convention, setting aside national legislative provisions which might prevent the Convention from having full force and effect. To paraphrase the European Court of Justice conclusion in the Simmental case, a different behavior would affect the very essence of European Convention's system. Thank you.